Morning, everyone. It is 9 o'clock, November the 18th. It is the quarterly meeting of the Tennessee Auctioneer Commission. Before we have roll call this morning, I do want to introduce a new member of the commission, Mr. Kimball Sterling. Appreciate your service. Glad to have you here. You have anything you want to say? Introduce yourself real quick.
I'm here to serve.
Thank you. Glenn, we'll have the roll call.
Thank you, sir. Jeff Morris. Here. John Thorpe.
Here.
Randy Lowe.
Here.
Kimball Sterling.
Here.
All right.
Four members are present, so we have a quorum. Thank you, Glenn. Notice of meeting.
Notice of the November 18th, 2019 meeting of the Auctioneer Commission was posted to the website on November 8th, 2019.
All right. Does anyone have any additions to the agenda, any changes that need to be made? If not, I'll entertain a motion to be approved as written.
One right quick, if you don't mind. I'm sorry to interrupt. It occurred to me this morning that we do have the newsletter. So we do have an opportunity to review that if that would be the will of the commission. So if we could add that maybe to new business, if that would be okay with the commission, we appreciate that.
So noted.
Thank you, sir.
All right. Commissioner Morris has moved. We accept that. Is that okay with the addition?
Yes, it is, with additions.
Is there a second to that?
Second.
Second. All in favor say aye.
Aye.
Any opposed? No. Let's have it. August minutes. Everybody had a chance to look over those. When you're ready, I'll entertain a motion those be approved.
I move that we approve them as written.
Motion's been made to approve the minutes from August. Is there a second?
Second.
Properly second. Any discussion? All in favor say aye.
Aye.
Any opposed? No. Continuing education seminars.
Okay. We've got the first two dialed up there on the education review number 3 on your iPads. And instead of enumerating each of those separately, so you're not going in and out of each document, we're just going to continue on. So we'll start with the CE seminars, and then we'll move to the other items as well on the list. So I guess we'll start with the CE seminars. I know that you had an opportunity to look at that probably about a month ago or so, and but it's before you again here today. We didn't actually vote on it at the last meeting, so we'll need to do that today. Just for a summary, we've got 1 hour there for Unleashing Your Inner Champion. Then we have 2 hours for Inside the World of Equipment Auctions, and those are both by Dustin Rogers. And then the second one for 3 hours, we have Estate and Financial Planning for Auctioneers as small business owners and independent contractors. A total of 6 hours. Yes, sir, that's right.
As I read it right, they're looking to have this online as well as.
These are the ones subsequent to here. These are the CE seminars that they'll be conducting per their contract to offer free to all of our auctioneers.
I got you. Throughout the year.
Yes, sir, that's correct.
For 2020?
Yes, sir.
Okay. I move that we approve them.
Motion's been made. They be approved. Is there a second?
Second.
Properly second. Any discussion? All in favor say aye.
Aye.
Any opposed? No. All right.
Great, and then these next two are the ones that you were referring to, Commissioner Morris, both by the Nashville Auction School. These are programs that have already been approved on Classroom but are being offered online. The first one being the 2019 Law Update and Review online for 2 hours. And then we also have one subsequent to that, the Law and Contracts, also online for 3 hours, and that's on page 7 of 18.
Since we've already looked over the other and approved them for the live class, I don't see a problem online, so I'll make a motion we approve those.
Second.
Motion's been made and properly second to approve. Any further discussion? All in favor say aye.
Aye.
Any opposed? No. It's approved.
All right, great. That moves us to our last item, bid calling boot camp. That is on page, let me get there myself, 16 of this presentation. And
what was the confusion on the 3 versus 6 hours?
It was from their statement. It was a typo because they had. If you look at the next page, that this is the original application. I included it for that reason because I wanted you to see what we had at our last meeting. They had 6 hours at the top, but then if you go to the front page of their application, they put 3. So we typically go by the application, not the outline. And so we presented it with 3, and they were saying that it was intended all along to be 6.
We already approved it, we just need to approve it for 6 hours
That's
versus
correct.
3. Okay.
Yes, sir.
Make a motion to approve.
Second.
Motion's been made and seconded to approve. Any discussion? All in favor say aye.
Aye.
Any opposed? No. It's approved.
Thank you, gentlemen. We'll move on to the budget then. This will be just for informational purposes, nothing actionable here for us to discuss or to vote on. Obviously, I'll answer and entertain any questions that you may have throughout or at the end as well. But we'll start here with the reserve. At our last meeting, we covered everything through the end of fiscal year 2019 or June of this year. So we will be primarily looking at the last 3 months of this fiscal year, but just sort of as a recap, I just wanted to kind of touch on our reserves, recap what we covered last meeting, and then pick up with the new months. All right, so what we're looking at here then is the Education and Recovery Fund. The total balance there is $298,000 roughly there. So that's tracking pretty well. We're not adding much to the reserves, but we're adding a little bit. I imagine, though, is if we can market the CE seminars, that we'll cut into that a little bit, because obviously with more participants, more expense, for the facilities and the like. But we'll watch that, keep an eye on that. It is required that you have $150,000 in that fund, and that's what the letter is on the next page. It's just stating what we have in excess of that and where those are coming from. So that's at a really good place. We got $150,000 roughly more than what we need, but there's the opportunity there with the seminars, that if everyone was coming to those, that we would see a decrease in those reserves. So and when we want folks to take advantage of that, that's what the Education Recovery Fund is. But yes, sir.
They charge per student, is that?
No, sir. That's made available to them free.
So your comment about more people coming, how does that affect us?
They bill according to facilities, and they provide refreshment.
Oh, okay.
So if they had more folks coming, then they may need a bigger facility, which would their operational expenses would go up, which would be reflected in this.
So it's almost
reserves.
a wash right now, which is good.
Right. So we're at a really good place. It's stabilized, and that's where we want to be. Okay, that takes us to our operational budget, the reserves overall picture. We've touched on this, I believe, recently, but just want to, before we move into the next fiscal year, just want to give us kind of a snapshot of where we're at. We're looking at, you can see expenses and cost backs are very top of these of the budget here, and then the revenue at the very bottom. Mr. Sterling, you'll see the total expenditures near about 3/4 of the way down, and then you'll see the licensing revenue there, case complaint revenue, net revenue, and then when that's all reconciled, what the total budget is at the very bottom. So fiscal year balance for this year was $11,000 surplus added to the balance, which gives us a total balance of about $473,000. So.
Question, have you done any performance on the fact that we don't have gallery and firm license now, how that's going to affect us?
It's very, very intuitive of you that you would ask that question. I was going to touch on that. We were thinking that the bid caller license would sort of make up the difference, what we would lack in gallery and firm, and that just isn't the case. We've had right now one application since that new statute. So we'll just have to watch it. Really no one knows until you kind of turn the light switch on, and so that's kind of what we were waiting on. But now that we've been into it for a few months and not seeing that uptick now, we could have a wave of them within the next quarter, but not right now. We're not experiencing that.
My experience so far is that a lot of people don't know about it. So
Right.
If the more that gets talked about and the more people that do it, it might have some impact.
Good point.
What about the increase in the salaries, wages, and bennies? What was that about?
And got it right.
That's why you're seeing that sharp upturn in expenses
Yeah.
right there, right? No, One thing that we did have, we had a realignment of our boards, and Roxanne and I both had roughly about 15 boards that, and centralized boards that we were supervising. They carved out several of those boards, and they maintained a separate arm called property boards, real estate appraisers, home inspectors, architects and engineers, soil scientists, geologists. Those came out from underneath us and to their own director. And so as a result, there's going to be less boards to share those operational payroll expenses. So the boards that remain, to include auctioneers, are going to share more of those expenses. So you'll see an uptick there as well in the payroll Edison expenditures across being allocated. Yeah, good catch. Yes, sir. All right. Let's talk about the overall. Let me just give you the trend analysis. Mr. Sterling, for your benefit, I'll just direct you to the very top and the bottom. We have revenues up top. You have licensing revenue that's coming in, and this gives us a per month snapshot, so we're not waiting on a quarter. We got basically real time of what's happening with the operational budget. Case revenue would be whatever comes in from the case complaints. You know, when we levy fines and those are paid, that's articulated there. State reg fee, that's a workaround by fiscal, finance and administration. They print our licenses for us, and so as a result, it could be considered a expense, but the accountants, they consider that reduction in revenue for whatever reason. That's fine. That's why you have the brackets there. And that's about $5 per license there. The Edison expenses, those are basically the line items within payroll, accounts payable. Everything in those line items there. That includes payroll, technology, anytime we do enhancements. Other things those are articulated and given to us in the form of expense reports, but it can be any of those sort of miscellaneous items, supply, things like that can fall into those. Administrative cost backs, those are the same accounts as Edison, but distributed across all the boards proportionally. Some boards carry more of the share than others, and sometimes it's not listed on the budget item, but they have to have a place to put it. You know, for example, when we were moving from the 9th floor to the 4th floor, and we were hiring movers to do that, and IT staff to rewire the place for us to move in that space, we're going to share that expense with all of the boards, and proportionally based on the size of the program, licensees, complaints. That's how they come up with that proportion. So that trickles down in administrative cost backs. That's where you see that. And then, of course, centralized complaints, not a whole lot there. That's our call center. Legal cost backs, that'll be typically a big chunk. Anytime our counsel and our disciplinary action team, whether we have a law change and we're working on new rules, that billable hour will be seen there. If there's a formal hearing, you'll have more in the legal costs because now they have to prepare for that hearing. Or if we have a rather large complaint report and they're working on those complaints, you're going to see more of the billable hour there. That all reconciles line by line, and where we can track the net surplus and or deficit throughout the year. You've noticed that we ended up with a surplus for that year of $11,000, so that's pretty good. We're not dumping a lot of money in the reserves. We've got that pretty much dialed in right now. So that's even with some of the additional expenses we have with the law change. Now let's go to this fiscal year, and you'll look at these 3 months here. I'll just give you a quick recap. There was a reallocation of legal costs that was distributed back to our programs in November, December of the last fiscal year, which resulted in a noticeable increase in operational expenses for those 2 months. We also noted the legal cost backs from February of last fiscal year due to litigation work. In June, we also we noted an increase in expenses compared to the 2 previous months, primarily in technology and legal cost backs, which will result in the law changes and the core functionality that was added to accommodate all that. If you go the one prior there, in 2019, June, there was a lot of technology and legal cost backs. Some of that was just trying to facilitate that new license. Now, we covered all that last meeting, nothing new there. But bring us the first 3 months here, July through September. August, you have other expenses. We're due to travel, basically our meeting and our NAA conference there, travel for that. So right there, that roughly $2,700 under other. That's that miscellaneous account, but that's tracked under Edison. That doesn't necessarily fall under benefits or technology, but any of our travel, which we had our meeting that month, and of course our conference. So that's what that is. Did see a reduction in revenue also in August. If you look at the very top, licensing revenue, July's got 13,000, August has got 8,000, September's got 14,000. So there was a reduction in revenue there due to a refund. So there was some refunds issued there. That's what that is. That was allocated out of that. Any questions about that?
I have a question, not about that. What's the difference in the customer service center and the centralized complaint?
They're two arms of the same branch, but they do have different functions.
So you call in, someone calls in, they get the centralized.
Depends on what they're trying to do. If they're just looking, they have an inquiry or they want a license, that'd be customer service. If they're calling in with a complaint, then for our legal team to review, then that would be that piece.
That just started this last fiscal year, right? I see there's no allocation back before that.
I believe that's correct. Let me take a look. Yeah.
That's in the centralized
Yeah,
complaints.
well, they had them last year as well. If you look at the last one, I like you, I do
Just see
recall.
18, 19 on mine. Nothing under 17, 18.
Oh, I see. Yeah, it may just not have been allocated yet. Sometimes they do that by quarter, so that may appear on the next trend analysis. But that's marginal, and thank you for that question. That's going to be marginal anyway. That's proportionate to the programs, just for their administrative costs to take those calls. All right. Any other questions? All right. That was just for our edification there. We'll move on then to the next item of business. Then it looks like meeting dates. Let me get there myself.
One thing, point out, Commissioner Morris pointed out, November 16th, I think it goes hand in hand with the TAA. So that's.
It works well for me,
Yeah.
so that's good. So those dates look great.
Good.
Anybody have any objection to those? If not, we'll need a motion to
Yes,
approve those.
So moved.
Motion's been made to approve the dates as printed. Is there a second?
Second.
Second. Any discussion? All in favor say aye. Any opposed? No. It's
The only comment I'll make, it seems like the quarterly meeting seems like we get it all done in time anyway, so it's working out well, I think.
So
Versus
too.
the 6 or 8 that we used to do.
And I appreciate your efficiency in that regard too. The commission's done a really good job just staying on point, and of course Chairman Thorpe as well, facilitating the meeting, keeping things moving along. So thank you all.
Thank you, Ed. That was approved. Next item is the legal report.
Let me introduce you to our new attorney as well, disciplinary counsel, Miss Kristen Downey. She'll be driving this one today, and she's sitting over here to Miss Matlock's right. So,
Good morning, everybody.
Welcome.
Sorry, I'm trying to get all set up over here.
Kristen, we're a tough board, so you better be on your best.
Do not scare her.
All right, so we'll get started. 29, number one is 2019. Ooh, a lot of feedback. Okay, number one is 2019-065941. Complainant is anonymous and respondent is a licensed auctioneer. Complainant alleges that respondent is engaging in unlicensed activity. Respondent attached a newspaper advertisement for an auction in which respondent is listed as the auctioneer. Respondent answered the complaint. I don't know what's going on, guys, sorry.
that one's a little fussy sometimes. If it gets bad, we'll just move you to the other one.
I think I'm just gonna go with like, okay. Okay, all right. Respondent answered the complaint stating that respondent is licensed and provided information from the commission's website to prove that respondent is licensed. Counsel verified this information and determined that respondent is licensed and the complaint should be dismissed. So that's my recommendation to dismiss this one.
I think that one's pretty cut and dry there. I'll make a motion to dismiss.
Second.
Motion's been made to concur with council's recommendation and dismiss 2019-06-5941. It's properly second. Any discussion? All in favor say aye.
Aye.
Any opposed, no. Dismiss. Number 2.
Number 2 is 2019-066941. Complainant is a Tennessee resident. Respondent is a licensed auctioneer. Complainant alleges that they negotiated to buy equipment from respondent for $700,000 with the $140,000 down payment and $10,000 as a buyer's premium, which would go toward respondent. Complainant alleges that they wired $150,000 to respondent to hold in escrow until the closing of the real property, which was scheduled for November 8, 2018. Complainant learned that respondent converted escrow funds to their own use. As a result, the closing did not go through. Complainant alleges that the respondent acknowledged converting the escrow funds. Complainant alleges that respondent offered to reimburse complainant for the sale of the real property owned by a limited liability company in which respondent was ostensibly a member. Complainant agreed to this. However, respondent appears to have sold the real property to another party and has not reimbursed the complainant. Complainant also attached a copy of respondent's indictment for theft over $60,000, which was issued in Tennessee. Respondent alleges that the transaction was not an auction and does not involve a property located in the state of Tennessee. Respondent alleges that it is a complaint that does not fall under the Tennessee Auctioneer Commission's jurisdiction. Respondent alleges that the property is located in Indiana and is not an auction sale. Complainant filed a rebuttal via complainant's counsel. Complainant stated that the commission does not have disciplinary authority over licensees regardless of where the property that is the subject of the transaction is located. Complainant further states that the primary issue addressed in the complaint is respondent's wrongful conversion of complainant's funds from respondent's trust account located in Tennessee. Complainant alleges that respondent violated TCA 6219, 112B2, 4, and 12. Counsel reviewed the documents attached to the complaint by complainant's counsel. It appears that the sale was not an auction, but rather a real estate transaction. Additionally, the real estate contract was entered into for the sale of property located in Indiana. While this transaction does not appear to be an auction, it does involve the conduct of the licensed Tennessee auctioneer and therefore falls within the jurisdiction of the commission, but I wanted to discuss this one. So in reviewing the rules, to me, it appears that it doesn't explicitly say conduct involving an actual auction is subject to discipline, but it seems that that would be the only thing that makes sense in order for us to discipline someone for any fraudulent conduct. And here, what it seems heard was more likely involving a real estate transaction rather than an auction. So I don't believe that we could necessarily discipline them for that transaction. But I wanted to talk with you guys about this conduct of this person in misappropriating funds, embezzling.
Would the funds, were they deposited into the auction escrow account?
It doesn't appear that it was an escrow account for auctioneers, for an auctioneer or anything. It looks like it was just a limited liability company that didn't involve auctioning.
His escrow account, unless he has a separate escrow account for a real estate company and a separate escrow account for his auction company, typically they're one and the same.
Okay, and that's why I wanted to talk about it, because I just wasn't.
So typically an auctioneer won't have two separate escrow accounts, you know, and for him to say that he's hiding behind the fact that there wasn't an auction, I find that a little bit trying to skip by. And did they file a civil case against this case?
They did, but.
Is that pending?
It's pending.
Was it a civil or was it a criminal
I'm sorry,
case?
a criminal matter.
All right.
It's a criminal matter, I'm sorry.
Criminal matter?
Yes,
But
and
did they file a civil case as well?
Not that I'm aware of. They didn't provide me with any of that information, so I only have the criminal matter.
Well, we can suspend licenses based on activity like this, and I would be moved to do that. I mean, for him to violate to take personal funds, take money out of an escrow account and use for personal funds, and admittedly doing that is a strict violation.
It definitely falls up under the rules. I just wanted to get you guys to weigh in on kind of what your thoughts were.
This is exactly the kind of guy that we don't want to have licensed as an auctioneer in the state of Tennessee, I can tell you that.
So there was no conviction yet, but I do think that, in my opinion, discipline would be appropriate. I just by you guys and just discuss them.
I would like to find out what is the maximum that we can do for, and so that would be if that's revoking his license.
I mean, under the statute, you can suspend. Let me pull up the statute real quick.
So I might recommend placing this complaint into litigation monitoring status. There is a pending criminal conviction, but we don't have criminal complaint, but we don't have a conviction yet. And I think it would be premature of the to suspend or revoke a license without an actual conviction.
Okay.
We could, what we usually do in these type of circumstances is the individual agrees to sign a litigation monitoring consent order, and then they are required to update us on the case as it goes. And if it turns out that this individual is convicted, ultimately, that's something the commission can take under advisement and make a decision then. I just would want to caution taking something severe when we don't have an outcome yet, because as we know, innocent.
Anna, that's why you're here. You try to keep us straight, and we appreciate that. But I agree with you, but whatever we need to do, I don't want this to be swept under the rug. I want it to come back before this commission once we find out what happens on this case.
Right, absolutely, and we can make sure that we'll just put very strict outlining guidelines with, I'm sure the respondent has their own legal counsel with their criminal matter. What's going on?
Okay.
I understood in the orientation this morning that we couldn't rule against any type of person that could not take in consideration a felony conviction or a conviction. It's what I heard that this morning. I know.
So I think that you maybe are referring to the Fresh Start Act. So the Fresh Start Act, I'll just give a refresher for everyone, is regards specifically to criminal convictions, and it allows individuals with certain criminal convictions to be considered for licensure. It applies mostly to future applicants, but there's a debate as to whether it applies to current licensees as well. There are certain criminal convictions that have a rebuttable presumption that they apply specifically to the profession. So those are most likely going to be Class A, B, or C felonies, and then also the enumerated felonies that are found within our statute. So that is... so currently our statute says that if you have a criminal conviction involving moral turpitude or a felony, then you would need to come before the that's something that can be considered. But if this were to, we're not there yet because we don't have a criminal
Right, don't
conviction.
have a conviction.
So we can certainly take into account later after that's happened. But, for example, if we had someone that was applying for licensure, that is something we can definitely take into account. It's just on the chance that the individual's license is denied, or if we take something such as suspending or revocation, there are certain factors that we would have to go over on the record, and those factors mainly help us. There are like 6 different factors about the time of the conviction, its specific applicability to the profession.
Will the real estate board also be considering this same complaint?
It's, I don't know if there's been a joint complaint, but it is possible, like that's within your discretion to also refer it over to the real estate commission. So you can do litigation monitoring and refer the complaint to the real estate commission.
No place in the rules for a temporary revocation until a trial.
Right. There is, I think what you're maybe thinking about is summary suspension. So when you summarily suspend someone, it's when you believe that person is, there's going to be immediate harm of the health, safety, or welfare of the city. But I don't think this particular instance would be a good example of summary suspension. But that is also an option if something like that were to occur. So you wouldn't want, there isn't really, we can't revoke someone's license just unilaterally.
Suspend it?
You could suspend their license, but the thing is, the individual has to agree to the suspension. If they don't, then it would go to a formal hearing. So what happens is you recommend suspension, we send out a consent order, and the individual agrees or disagrees. If they disagree, then it's sent to an administrative law judge, and we would set that for a formal hearing.
I agree with what you were saying. You know, if we could, whether he agrees with it or not, we'd wish that he would, but I think you're right, and we need him out. We don't want him in our business.
Well, let's go with the council's recommendation here and do litigation monitoring and refer it to the real estate commission, and I make that move and that motion that we do that.
Motion's been made to place this on litigation monitoring and revisit it at a later date. Is there a second? Properly second. Any further discussion? All in favor say aye.
Aye.
Any opposed, no. Number 3.
2019-069371. Complainant is a licensed auctioneer. Respondent is an unlicensed out-of-state resident. Complainant alleges that respondent is engaging in unlicensed activity. Complainant alleges that a firm license and licensee number is provided on the advertisement but cannot be found as a registered licensee. Complainant alleges that respondent has conducted multiple fraudulent auctions in the past in other states using other individuals' names. The complaint was sent to respondent on August 20th of 2019. The complaint was sent back as not deliverable. Counsel sent an email to respondent with information regarding the complaint and informing the respondent of their opportunity to respond. To date, counsel has not received a response from respondent. Counsel conducted an independent investigation and respondent does not appear to be licensed in Tennessee. I recommend a civil penalty of $1,000 for unlicensed activity, but I will note that the respondent is not obligated to provide a response as he's not licensed in the state of Tennessee.
Can the respondent go online and see the words, the respondent is unlicensed with no duty to respond before the meeting?
No, it won't
He
be.
can't see this.
No, it won't be published until the next set of minutes that come out, which would be in February.
You can watch it
How
live.
many instances do we know of that he had auctions? Do we?
I just know of the one. I don't know of any other ones.
They did several, so I didn't know what that meant.
That's just what the complainant alleges, but the only information I can find was for the one that was complained of. So they don't have to respond to the complaint, but if we discipline, then I mean, they would need to provide the
What-
money for this penalty.
So if we have an out-of-state auctioneer and he just decides to come here and do them, and we send them fines and they ignore us, we have no recourse against them at all?
We send out the consent order and they don't respond, set for a formal hearing. They don't respond for a formal hearing. They don't show up to the hearing, we most likely default judgment, and then they would have an outstanding judgment, and then after so many times it is sent to collections, but they would have an outstanding judgment in the same. So it, like, we can't force anyone to pay anything, but we will have a court order, and it would be sent to collections, and then that'll be the collections' responsibility to try and obtain those funds.
You will have a court-ordered judgment.
Right, so if we send out a consent order for unlicensed activity, the only thing is that we'll need to fine them also in order to serve them for the complaint. But if, say, example, we do fine them and they're served, set for a formal hearing, they don't show up, or if they show up, they would then, there would be a court submit it, and then it would go to collections. Also, they would not be able to get licensed here in the state of Tennessee until they pay their complaint. And
They decide they don't want to ever get a license in the state of Tennessee, and they just come and, we have these auctions come in, they set up in a hotel room and, do their thing, and then they're in and they're out, and they're not licensed, they don't have a license, they don't advertise a license, and they just say, we're going to have this, the state auction, quote unquote, and
right, but if they're licensed in another state,
not licensed anywhere.
if they're not, but if they were on the off chance, we can also send that judgment to that specific jurisdiction. It's difficult sometimes with our unlicensed individuals, but we do try and exhaust all methods in order to get them served and collect the judgment or civil penalty.
Well, I move we do what we can,
Okay.
and agree with the council's recommendation for a $1,000 civil penalty.
Motion's been made to concur with council and recommend a civil penalty of $1,000 for case number 2019-06-9371. Is there a second? Properly second. Any further discussion? All in favor say aye. Any opposed, no. The ayes have it. Number 4.
2019-07-0821. Complainant is an anonymous individual. Respondent is an unlicensed individual. This complaint was opened administratively based on information from the August 12th meeting. Complainant alleges that respondent was engaging in activity. Respondent filed a response stating that they have never acted as or performed as an auctioneer. Respondent states that they are a seller of several auctions. Respondent states that the only role they play at the auction is to bring merchandise to set up in the building to sell. Respondent states that they also pray over the auction at the beginning of each auction. Counsel an independent investigation, and it appears that the respondent is only a seller of antiques and furniture. I didn't get any indication that they were actually conducting any auctions, so my recommendation is to dismiss.
Move we dismiss.
Motion's been made to concur with council's recommendation and dismiss 2019-07-0821. Is there a second?
Second.
Properly second. Any further discussion? All in favor say aye.
Aye.
Any opposed? No. It's dismissed. Number 5.
2019-07-0801. This complaint was opened administratively. Complainant is anonymous. Respondent is an unlicensed individual. The complaint alleges that respondent was conducting business as an auctioneer without a license. A response was filed on behalf of the auctioneer firm stating that the respondent is not involved with any auctions held by their firm. The response stated that their auctions always have a licensed auctioneer. Counsel conducted an independent investigation. It does not appear that the respondent is a licensed auctioneer. Respondent did not provide a response and is under no duty to respond as respondent is unlicensed. I didn't have any other information or find anything to substantiate the complainant's complaint of unlicensed activity. So without any further information, I recommend that we dismiss the complaint.
Make a motion that we concur with the council's recommendation for dismissal.
Second.
Motion's been made and seconded to concur with council's recommendation and dismiss 2019-07-08-01. Any discussion? All in favor say aye.
Aye.
Any opposed? No. It's dismissed. Number 6.
2019-07-6791. Complainant is a Tennessee resident. Respondent is a licensed auctioneer. Complainant alleges that respondent placed for sale signs on their land with an asking price of $4,000 per acre. The sellers were complainant's neighbor. Another neighbor purchased some of the acres of the 15 available for $4,000 an acre. The neighbor was then refunded 1/3 of the money after the deal closed. The neighbor was told by respondent that this was how it had to be. Complainant alleges that respondent also sold 127 acres of land on Complainant Road without listing it on the list. Complainant states that they had no chance to purchase the land, which sold for $1,100 an acre to a developer. Complainant states that their privacy and property value are badly damaged by the respondent's underhanded dealings. Complainant further alleges that respondent's license is expired. Respondent alleges that their buyers and seller involved in the transaction were pleased. Respondent states that the property was sold and then 1/3 of the money was given back to the buyer because the buyer was also 1/3 heir to the property that was sold. The buyer was given the buyer's 1/3 of the income received, as were each of the other heirs. The buyer now owns the property outright, as the other heirs had no desire to own the property. Respondent alleges that all parties involved were in agreement with this arrangement. Respondent further states that the complainant's allegations that a property sold by respondent was not listed on the MLS is inaccurate. Respondent states that the property was actually listed on the MLS on April 26 of 2019. Respondent provided a listing number. Respondent also states that there was a signage with the agency name and phone number placed on the property and all appropriate procedures were followed. Respondent admits that their license is expired, but states that this information is irrelevant as the property was sold outright and not auctioned. Respondent states that due to health reasons involving the office coordinator, respondent's license had lapsed, but the issue has been resolved. Complainant filed a rebuttal stating that respondent is not being honest in their response. Complainant alleges that respondent told the buyer that they were required to purchase the entire property to be paid back. Complainant further states that respondent cannot sell real estate with only an auctioneer license that was expired when the transaction took place. Complainant alleges that the respondent's auctioneer license expired in February. However, they held an auction in March. Complainant attached a supporting document showing that the respondent held an auction in March. Council recommends a $1,000 civil penalty for the unlicensed activity in March.
Okay, so this is a little fuzzy to me.
Yeah.
The respondent is a real estate agent and an auctioneer?
It appears the respondent does not have a real estate license. They have an auctioneer.
Selling it on
license.
behalf of somebody else?
Say that again. Yes,
Was he
yes,
selling
yes. Correct.
It wasn't his property?
Wasn't the respondent's property.
Okay.
So the issue, all of that is involving Trick, obviously. But the last part about them conducting an auction in March and providing supporting documentation for it is where I took issue, and that's why I recommend the penalty.
Their auction license lapsed in February, or expired in February, and they had an auction in March.
Correct.
The recommendation is based on
That violation.
the one in March after the.
Right.
So this whole case has nothing to do with the penalty at all.
No, and I think the complainant probably realized that in the rebuttal and just provided information on the unlicensed activity in March and substantiated it with the supporting documentation. So without anything else, all I can do is recommend that they receive discipline for.
So wait a minute. So how did they have to establish a price of $4,000 an acre if it was an auction?
I'm assuming there was maybe some sort of appraisal or something.
Oh, man,
I'm not really.
you don't do that in an auction. In the auction, you sit up there and call bids, and the high bidder establishes the price.
Right, so that part of the complaint is not what I'm basing the discipline on, because that
I
sounds just
understand
like
that, but how did they sell a property with a set price and haven't, and I'm confused, what was the auction for?
I don't think there was an auction,
Well, then how can we find them if there wasn't an auction?
because there was a different auction that they were advertising for that didn't involve any of what the
Wait,
complaint.
back up, what, so what auction did they have in March?
It's unrelated to what the complainant complained about. This was something else. I can look up the.
Yeah, but we didn't have a complaint filed about the March auction. It was about the land that was sold for $4,000 an acre that wasn't right.
That
Right.
says in here, April 26th, that land was listed with multiple listings.
And there's no requirement that any land ever be listed in multiple listing. I mean, that's not a violation of anything. So I don't know. I'm confused.
I think there are two separate incidents that we're talking about. There's one with the real estate transaction. One that occurred afterwards that has nothing to do with real estate, and I believe that's what Miss Downey is basing her information
But the
on.
complaint didn't file a complaint about the auction, the March auction.
Well, they filed in the rebuttal. They complained about it in the rebuttal. So based on that information, that's where my.
I'm not going for that. I mean, I appreciate that, but I mean, this is, without knowing more about this, I'm going to pass on doing anything myself.
Sounds like it's a real estate commission issue if they don't have a license.
You can make a motion to refer it to the real estate commission.
I move we refer it to the Tennessee Real Estate Commission. I don't believe it's in our jurisdiction yet.
I second that.
Motion's been made and seconded to simply refer this case over to the Real Estate Commission and take no action on our part. Is there any discussion? All in favor say aye. Aye. Any opposed, no. The ayes have it. Number 7.
2019-077511. The complaint was filed anonymously by a licensed auctioneer. The respondent is an unlicensed individual. Complainant alleges that respondent conducted a benefit/fundraising auction on September 12th of 2019. Complainant alleges that the auction/event was contracted and conducted by 2 unlicensed individuals. The complainant alleges that the company is owned by an out-of-state resident. Complainant alleges that the auction/event had a licensed Tennessee auctioneer who was paid by respondent. Respondent filed a response stating that they have been in business since 2007 and licensed in Kentucky, Illinois, Indiana, and other jurisdictions. Respondent states that one of their apprentice auctioneers conducted the auction at the request of a client. Respondent admits that their firm is not licensed in Tennessee. However, respondent states that their apprentice auctioneer was practicing on a volunteer basis. Respondent admits that the firm received compensation for the auction fundraising consultation and not for auctioneering. Respondent states that they were initially hired to provide fundraising consultation for their client's event in April. Their client then inquired about using respondent for future events. Respondent states that they were very busy for the dates that the client inquired about, so they asked their apprentice if the apprentice would be available. Respondent states that they have never reached out to a Tennessee client to solicit business as they are not licensed in Tennessee. Respondent states that they plan to obtain a Tennessee license in the future. Respondent states that the complaint was filed by a former employee who did not leave the company on good terms. Counsel conducted an independent investigation. It appears that the auction was a charitable auction. However, respondent did not receive compensation for their auctioneering services. The apprentice auctioneer performed the service pro bono for charity. Since the respondent did not receive proceeds for the auction, they followed within the exemption provided in Rule 0160-01-17. So counsel recommends dismissal.
I make a motion we accept council's recommendation to dismiss this case.
Motion's been made to concur with council's recommendation and dismiss 2019-07-7511. Is there a second?
Second.
Properly second. Any discussion?
I just wondered something about this. Did y'all check with the charitable organization to see if they paid this gentleman anything, or are you just going on his word?
I didn't reach out to the organization. The individual provided me with the information, so I didn't.
But I know a lot of times in charity auctions, there's a lot of auctioneers today that are just doing charity auctions. I do a lot for free, but there's a lot of companies that go out and do them and charge for them. And he may say he didn't get paid for it, but you might have checked with the charitable organization and see if they actually paid him, because a lot of those guys make pretty good money today, traveling around doing sales. He could have been paid, and he may be telling you he's not been paid, is what I'm saying. But the charitable organization would have written him a check, and you would know whether they paid him or not. There's a little fine line there. I know that 160.01 or whatever, we can all do charity auctions. You don't have to be licensed. But this guy could have been paid and maybe telling you something by mistake, or you're not telling you the truth. But the charitable organization should be able to tell you whether they paid him or not. And it might make a difference in the situation. You understand what I'm saying? You guys understand what I'm saying? You understand these guys that travel through and charge $2,000 to come in and do your auction, and I'm sure you guys do it for free like myself.
All right, I have a motion on the floor and a second to dismiss. Any further discussion? All those in favor of dismissing, please say aye.
Aye.
Any opposed, no.
No.
Have a roll call vote, Glenn, if you will.
Mr. Morris,
Aye.
Mr. Thorpe,
Aye.
Mr. Lowe, and Mr. Sterling.
No.
All right, just let the record reflect that a majority then consensus, and as a result, this motion would pass. All right.
Motion has passed. Number 8.
2019-077811. Complainant is a Tennessee resident. Respondent is a licensed auctioneer. Complainant alleges that they purchased 2 mowers at an auction on September 14, 2019. Prior to purchasing the mowers, respondent contacted the company to get a preview of the condition of the mowers. The company advised that they would find out the condition and update complainant. Complainant was later advised via text that they in reference to the mowers, run and cut grass as they should. Complainant states that they bid on the mowers aggressively. Complainant won the bid, and complainant states that they called the following Monday to let respondent know that complainant shippers asked them to personally verify the running condition and would like to come in to do so. The auctioneer on call responded, "You bought them. I don't care what condition they're in. You bought them and you're going to pay for them. These are cheap mowers and might run, but that's it." Complainant states that the respondent misrepresented the condition of the mowers. Complainant also states that respondent relied on an auction gallery number to advertise, which is no longer in use. Complainant states that respondent never advertised any auctioneer number in any of the complainant saw. Complainant states that they contacted the owner and asked about the auctioneer number. Respondent retorted, "I'm not going to give you the auctioneer numbers. That's none of your business." Complainant attached a copy of the advertisement and copies of text messages indicating that the mowers run and cut grass as they should. Respondent filed a response stating that they dispute the complainant's allegations, as they do not, nor have they sold any mowers online or through any other avenue. Respondent states that they do not know complainant. Counsel conducted an independent investigation. It does not appear that respondent is at all associated with the auctioneer firm indicated by complainant. And without any further information, I recommend dismissal.
Reach out to the complainant to see if he had the right auction company?
No, I didn't get any information from the complainant, but we can.
It sounds like they might have got their auctioneers mixed up or something.
Yeah, and even with that being so, this particular respondent isn't the correct one, so.
Are we sure of that?
From what I discovered, I'm sure that that's not the right individual, and I think there was a mix-up. But I can't do anything else other than dismiss it. This isn't the right person.
I know auctioneers are prone to puffery, as they call it, but an auctioneer's word ought to be an auctioneer's word, is whether they run or don't run.
Was this live as well as online, or just online?
It appears it was just online, but what I could do, I could reach out to we can dismiss this, and I can reach out to the complainant afterwards and let them know that they need to open a complaint for the correct individual.
The only reason I ask that is if it was a live auction, a lot of times, if John's having an auction and needs help and I go help him, my company really has nothing to do with it, so maybe the guy saw the other auctioneer and just assumed it was his auction and he was just there helping, so it would be helpful to know if it was live and online and who was working.
If you are sure that it's not the right auctioneer and he didn't have anything to do with this auction, then I would be okay with dismissing it. But I would like to know, sometimes like this guy's got a complaint that needs to be resolved.
I agree that they do have a complaint, but I'm pretty sure it's the wrong person. So I would advise that we dismiss this one, and I can reach out to the complainant and ask them to.
So moved.
I would definitely reach out to them and just let them know. Motion's been made to dismiss 2019-07-7811. Is there a second?
Second.
Properly second. Any further discussion? All those in favor say aye.
Aye.
Any opposed, no. It's dismissed. Number 9.
2019-083611. Complainant is a Tennessee resident. Respondent is a licensed auctioneer firm. Complainant alleges that respondent falsely advertised the tractor for auction. Complainant states that on August 10, 2019, respondent held an auction and one of the items was a tractor that respondent states works and operates. Complainant attached the advertisement. Complainant states that they bid online, so prior to bidding, they inquired as to whether the tractor was running. The respondent confirmed that it was. Complainant bid and won the tractor and arranged for pickup on August 12, 2019. When complainant got the tractor home, they noticed that the gauges were not working and it lacked power. The tractor would not go into gear or move forward or backward. Complainant states that they called respondent and respondent laughed and stated that it was the complainant's problem and that the tractor worked fine when it was used on the lot. Complainant contacted a mechanic who informed them that they had been sold a tractor with the faulty clutch/transmission, among other issues. Respondent filed a response stating that they held a business liquidation auction on August 10th of 2019. The auction was advertised on their website and the auction was online, where they were advertising a tractor with loader and backhoe. Respondent alleges that complainant spoke with the cashier after purchasing the tractor online and agreed to come in on the following Monday to pick up the tractor. Complainant arrived to pick up the tractor, and complainant stated that they did not know how to drive the tractor. An employee went to get a mechanic to start the tractor and show complainant how to start and operate it. Respondent alleges that the mechanic moved the tractor backward and forward. The mechanic operated the front bucket and backhoe when they drove the tractor onto complainant's trailer. Respondent alleges that after the tractor was put on the trailer, complainant asked the employee what their recourse would be if they did not like the tractor. The employee explained that it was an auction and the items are sold as is. The employee stated that they would be glad to sell the tractor for complainant in another auction if they did not like it. Respondent alleges that complainant admitted they did not contact the dealer or do any research on the item. Respondent alleges that complainant called on Monday night and wanted a refund and for respondent to pick up the tractor. Complainant alleges that they had the tractor in the field and it would not move. Respondent states that they offered to resell the tractor at the next auction for farm equipment and suggested to complainant that they get a mechanic to assist them. Respondent states that complainant called multiple times and had his senator send respondent a letter requesting that respondent pick up the tractor and refund complainant the money. Respondent stated that they informed complainant that they did not falsely advertise the equipment. Respondent attached the invoice from the auction, the letter sent to them from the senator, and the online description of the equipment. Counsel reviewed the documents uploaded by both parties. In the documents, it states that the purchaser understands that the auctioneer has not driven or operated any of the equipment being sold, and purchaser is buying as is and accepts all liability for the operation of items purchased and agrees to hold auctioneer harmless for claims resulting from the use of the items purchased. We do not guarantee the odometer readings or any hour readings on any items. In addition, both parties admit that the tractor was working when complainant came to pick it up. Counsel recommends dismissal.
Any discussion? What is the will of the commission?
I agree with the council. It ought to be dismissed myself.
I need a motion.
I make a motion that we dismiss.
Motion's been made to dismiss 083611. There's properly seconded. Any further discussion? All those in favor say aye.
Aye.
Any opposed? No. It is dismissed. Number 10.
2019-086471. Complainant is a Tennessee resident and respondent is a licensed auctioneer. Complainant states that they attended an auction on October 19th of 2019 and bid on a property. Complainant alleges that the auction advertisement stated that the information provided at the auction would take precedence over any advertising, so when the property was up for auction, the respondent did not set a reserve for the property before taking bids. Complainant alleges that they put a bid in for $100,000 and respondent refused to take the bid. Complainant alleges that respondent stopped the auction and stated that they would not lose any money on the property. Complainant alleges that respondent wrongfully advertised the auction. Respondent filed a response stating that they stated at the auction that if the reserve is met, then it will become an absolute sale. Respondent alleges that during the bidding, complainant bid $100,000, at which point the respondent informed complainant that they were too far apart and that they would need a bid of at least $175,000 to start. Complainant responded that they had $100,000 to start the bid. The respondent then turned to the auctioneer and told them to start the bidding at $175,000. Respondent states that shortly thereafter they stopped the bidding and started to sell personal property. Respondent states that they later looked at the advertisement and discovered that it stated that the auction was an absolute auction, which was a mistake made by the printing company. Respondent states that there was a brochure box attached to the sign with the sale flyers that did say that did say auction rather than absolute auction. Respondent states that they make sure to put on the sale flyers that sale day announcements takes precedence over all advertising. Respondent uploaded copies of the advertisement. Complainant filed a rebuttal, which was just pictures of the advertisement. Counsel reviewed the documents attached by both parties. It appears that the advertisement does indicate that the auction was an absolute auction, which is misleading. Counsel understands that this was an error on the part of the printing company. However, it is the respondent's responsibility to review the advertisements and make sure they are accurate in their representation. Counsel recommends a letter of instruction regarding Rule 0160-01-23.
Your discussions with them, are you convinced that it was an error and that they really did not intend it to be an absolute auction?
I think it's an error based on the fact that the advertisement that was on the cutout said one thing and then the brochure said another. So it looks like what they meant is kind of fuzzy.
Was there a sign on the property at all?
Hold on. I don't know if the sign was on the property or if it was just a sign indicating that an auction on that property was going to take place, but it doesn't indicate that it was actually on the property.
The advertisement, the only place it said absolute?
Right, so there was the sign that said absolute, and then there were little brochures on the, where you can take it out, that's connected to the sign that said auction.
What was on their website?
I'm not sure. I didn't get their website information. They just had flyers uploaded, so I only had.
The reason I'm asking these questions is there's a lot of auction companies will advertise an absolute auction, but only absolute above a certain number. Well, there's no statute that allows for that. It's either an absolute auction or it's not an absolute auction. And they try to play games with this, it's absolute above 170 if we get an opening bid kind of thing. And they're playing games with it and trying to abuse the word absolute. And we all auctioneers, we understand what that means and what the power of that is. And I don't like the fact that people play games with using that and say it's absolute above a certain number, or if I get an opening bid of X, then we're going to make it absolute. That's just, it's either an absolute auction or it's not. And so
I agree that they should make it clear, and whether it's a mistake or not, it's not okay.
I agree with Jeff, and there should be something that if it was advertised one way in 3 or 4 locations and then just one was a mistake, that would be a little easier to take, you know, if it was.
Also, the printing company, did you reach out to them and ask to verify that it was a mistake on their part?
No, but even if it was a mistake, I'm of the opinion that it's their responsibility. So it doesn't matter whether it was a mistake or not on their part, which is why I didn't really reach out to them.
Yeah, our
Right, I'm
printing
just trying
company
to
sends us
see if
something
it
to
was-
sign off
they were-
saying, is this right or wrong? And if we say it's right, then that's what they print. So
Yeah.
they have to.
A lot of them have it already set up, you know, from a previous auction. It could be, but just
And
trying to verify if they're intentionally trying to mislead folks to get more people to come,
Right.
or not, you know.
Well, they just have a responsibility to make sure their stuff is right, so.
That's true. They all absolute, and just this one came about, and they didn't change their.
I agree with what Jeff said about this being sold absolute above a certain price. There's no rule about that, is there, Jeff? I mean, there ought to be a rule or something, don't you think? I mean,
Well,
that's very
under the
misleading to the
UCC,
public.
there's only two definitions of an auction. It's either,
Yeah.
it's either an absolute auction or it's a reserve auction. And
That's
if you-
being used a
Unless
lot.
unless you say the word absolute, it's implied that it's a reserve auction. You know,
See, this-
80% of my auctions are reserve auctions. We never say the word absolute. But anyway, I don't know how to act on this one because I don't know where else it was advertised. If it was only the one sign that said absolute auction, and that's the only place that really matters. You know, if it had a brochure, that, you know, I don't know. And now I don't know what I don't know if they, when they did the auction, if they recorded it or not, but if they said, look, and it is the right of the seller, and this is the part that I don't like, but under the statute, it is the right of the seller to change the rules of the auction prior to the auctioneer starting the auction. He can convert it from an absolute auction to a reserve auction if he chooses to and instructs the auctioneer to do so. And I don't know if that happened or not.
That did happen. So they basically, well, I take it back. It wasn't explicit. What they said was whatever is said at the auction.
I know,
takes
and we
precedence,
all
but I don't-
and we all
right,
say that, you know.
Right, but I don't know if he actually said, "Hey, this is going to be this."
I don't know, did he make a correction from the block or not? So I don't.
So we have to go off of what we have and what we can show. So what we have and what we can show is that there was a mistake made and it was misleading. And because of that, I don't think that a civil penalty is appropriate, but I do think a letter of instruction
I agree
would be
with you, so
appropriate.
I will make that in a form of motion. We can send them a letter of instruction and be very emphatic about how the word absolute should be used.
So motion has been made and seconded or I need a second for that.
Second.
Seconded to concur with council's recommendation, send a letter of instruction on 2019-086471. Any further discussion? All in favor say aye.
Aye.
Any opposed, no. The ayes have it. Erica.
Okay, so I have 3 represents this morning. Would you like me to read the original summaries or just the new information and the new recommendation?
Can I ask for about a 5-minute break?
Yeah, if no objection, we'll take a 5-minute recess and come back.
Chairman.
All right, we'll call it back to order here. What does the commission want? Do you want it all read, or do you want to give Erica a break?
Perhaps you could just kind of summarize it, it'd be helpful.
I can definitely do that.
Thank you.
Okay.
Especially for our new member, he wasn't here before.
I did read it, though.
Okay.
They sent me all this to read, and I read everything. While I was driving 5 hours.
So number 11 is 2017-071-851. And basically, when this was originally presented, we found that there was a violation of TCA 62-19-102 for unlicensed activity. The respondent didn't have a firm or a gallery license. So since this matter was originally presented, the law has obviously changed, and auctioneer firm and gallery licenses are no longer required. So for that reason, and considering that there's not been any other issues since 2017, I recommend dismissing this case.
All right, so here's the deal on that. Something got missed between the task force and the way the law was written, and we're going to try to go back with a correction. The existing firm license, the existing gallery license that was basically a non-auctioneer owned gallery license, was supposed to be grandfathered in, but under the law it was not. And so it but we're still looking for a responsible auctioneer for each one of these firms. So I don't know if there was a responsible auctioneer.
I mean, I'm pretty sure.
I mean, if he had an auctioneer license, but not a gallery license, then I think we're okay.
Yeah, well, the respondent who owns the location where the auction happened hired a licensed auctioneer.
Okay.
And we also opened a complaint against that licensed auctioneer after I originally presented that and dealt with that.
But what was the problem? I mean, other than not being licensed, what was the problem?
I think that was the only problem.
Okay, so then I think we're okay then. I think we ought to dismiss it, and I make that motion.
Motion's been made and properly seconded to dismiss 2017-07-1851. Any further discussion? All those in favor say aye.
Aye.
Any opposed, no. It is dismissed. Number 12.
Number 12 is 2017-080-371. I'm just going to look at it real fast. Okay, so this is a very similar scenario. The respondent had a licensed auctioneer, but did not have a firm or gallery license. So for the same reason in the law change, I recommend dismissal of this complaint.
Same reason, I would make the same motion.
Motion has been made. Is there a second?
Second.
To dismiss 2017-080371. Any further discussion? All those in favor say aye.
Aye.
Any opposed say no. It is dismissed. Number 13.
2018-010-711. And this is a complaint that comes out of unlicensed activity. The complainant alleged the respondent sold complainant's merchandise at an auction and paid the complainant with 2 bad checks back in June of 2017. And complainant also provided copies of correspondence where he tried to discuss the bad checks with respondent and gave us the copies, but respondent has not responded to the complaint. I can say that I've exhausted every effort that I know of to try to serve the respondent, to try to contact him, to try to find out where he is. We ran a background check. And I think at this point, because we have had no other complaints against this respondent, nothing else has come up, that it would be a waste of our resources to continue trying to pursue it. But I would like to hear the commission's opinion on that, or if you have any questions or suggestions, I'm open to discussion.
They open up a civil complaint for the bad checks?
Well, this is the complaint.
I'm talking about a civil lawsuit.
Oh, not that I know of.
Okay.
No.
I mean, if they're trying to recover their money, then you would think that they would.
But that's what I thought too. I feel like after we're going on 3 years here. If it was that much, if it did that much harm to the complainant, they probably would have tried other avenues.
I would say not spend any more money chasing it myself.
Yeah, I know the respondent has a license in another state, and I tend to believe that the respondent has moved to where that license is and is no longer in the industry here. But that's just based on my research, my internal research. And
Would the claimant have a case against the recovery fund for those checks or not?
Anna,
Only after they file, they got to go through all the legal system first, and they have to exhaust that before they can make a filing with the recovery fund. In other words, you have to exhaust the civil courts and have the judgment and have it not paid before it would be applicable.
it also could be that the respondent may have paid the complainant since then. I don't know.
Yeah,
We usually hear from complainants, if something has not been resolved. So,
Motion's been made to dismiss 2018-010711. Is there a second?
Second.
Properly second. Any further discussion? All those in favor of dismissal say aye.
Aye.
Any opposed? No. It's dismissed. I believe that's the end
thank you very
of the
much.
road.
It was nice to see you.
We appreciate it. Red line rules edit.
So you'll find on your iPads a section of the rules that we have drafted that will be discussed at the rulemaking hearing in February. So following the Commission's approval, I sent these rules to the Attorney General's office after it was approved internally to the Attorney General's office for review for constitutionality. And the highlighted portion in number 4 was something that was brought to us during the discussion. As currently it states, all sponsoring principal or public automobile auctioneers shall reside in the same state as his or her affiliate auctioneers. However, in appropriate cases, upon good cause being shown, the Commission may waive this rule. With the updated changes in the rules in the statute, and that you don't have to have a principal location in Tennessee, the Attorney General's office had suggested that we remove this portion of the rules for individuals that may have a principal or public automobile auctioneer that reside outside of the state. Also, since there are no further restrictions on how many individuals can be supervised within the state, and since we can also always appeal this to the Commission, they just thought it would be something that was prudent.
So you're saying rule number 4 should be stricken?
Yes, that was the recommendation.
It didn't comport on your iPads, but the entire rule, only a portion of it showed up highlighted, but that entire paragraph.
But they're saying eliminate paragraph 4.
Yes.
All sponsoring principal, right, okay. Well, if you're not required to live in the state, why would we have that rule?
Right, exactly. This is just a rule that would be a holdover from the old statutes, and so it makes sense to remove this requirement since there's not a Tennessee residency requirement.
Oh, I agree with that. So
Okay, we don't have to vote on anything today. We'll just keep this in mind. In the rulemaking hearing, you are allowed to make changes to the rules.
That's in February?
Yes, it's going to be in February on the 24th here in this room. If you are signed up for e-Notify, you should have gotten one last week that lets everyone know about the rulemaking hearing date and the link to the filed rules. So this will just be a provision that we would recommend we would change during that hearing.
About living the residency.
Okay, I just wanted to bring it before you because this is a substantive change and not one that is, terminology change like our other rules that we've seen. That's okay. That's all I have.
You need anything else?
No.
Okay. All right, new business, have one item that I know of, the newsletter. just reviewing that, see if we like it, and vote yea or nay if we do.
Yes, sir. I just had a couple edits I'd like to draw your attention to. They're minor, but they will be corrected. That highlighted portion under, on page 1, where you see commission bid caller right there, commission will be capitalized, and that space will be reduced. But, so that's minor, just more presentation. Commissioners, we will represent Mr. Sterling, his appointment there as well.
Yeah, I was gonna say, take that open off there, put Kimber's name on there.
Other than that, that's all I had as far as minor edits to
Right.
what you have before you.
First newsletter, Kimber.
Oh, boy, I'm excited.
All right. You need a formal motion to approve that?
Yes, sir.
I move we approve it with the changes as written.
Motion's been made and seconded to approve it. Any further discussion? All in favor, say aye.
Aye.
Any opposed, no. The ayes have it. Any other new business? Motion we adjourn. Motion's been made.
That's fine. We're
Seconded.
gonna have that closed
Yeah.
door? Okay.
All in favor, say aye.
Aye.
We're adjourned, and we have executive session. 10:26.